My voice is okay, huh? I mean, loud and clear, right? Okay, that's good. Okay, there are some disclaimers to make before we begin. So again, this is a pro bono class, and I'm just somebody very junior in law, so I do not guarantee the accuracy of the answers. Okay, so please evaluate and assess the answers with extra cautious. Okay, and uh, okay, I believe you still have 5 days to go before your final exam. I mean, for those who have achieved conditional pass. So, um, in professional practice, personally, I think you should put more emphasis in two areas. Number one will be ethic and advocacy, and second part, don't miss your land law. Land law um, constitute three questions, out of the 9 questions asked. So what you need to do is to master your land law well, okay, very well up to the point. In the sense that if you are compelled or by situation force you to do, you can answer 3 questions of land. This will secure you a pass. Okay. And again, I would like to emphasize this all over and over again. Do not attempt to perfect your answers because you are in a manner of time rushing. So you have to read the question and then you have to answer by your natural reflex. That means to say your instinct. So virtually during the exams, it is a very stressful environment. Probably you could not sleep well the day before. So what will happen is, okay, you may be required to answer the questions that sounds very sure to you. That means to say that you don't have to read statute or you don't have to have second thought, then you can answer this question. Because the failing rate for PP is higher than other subjects. Reason being, it is not focused because it constitutes so much of different areas like you have bankruptcy plus winding up a company. Suddenly you have probate and then land and then ethic and advocacy. And unfortunately, you are just being provided with your legal profession act as well as your national land code. Sometimes you may forget the specific provisions of a statute. For example, Probate and Administration Act. So you cannot answer in a general way. So for this sort of professional paper, so this is the reason. Please, do not perfect your answer. Just answer from what we call start with the questions that you 100% sure. Subsequently, you move on accordingly. Okay. We'll discuss 2018 paper as well as 2021 paper. Okay. First question. Is this the privilege of only? Okay. You must read the question carefully. Anything that they put in italic form or capital form, that means to say emphasis added. So this is one of the important element inside that question per se. So this is to say only a privilege of only the advocate and solicitor to have exclusive right to appear and plead in all courts of justice in Malaysia. Discuss the above in the context of the relevant provision under Legal Profession Act 1976. So 10 marks being provided. At least looking at 10 marks question, you have to bear in mind that probably we are looking at 3 to 5 issues. That means to say at least one issue they will give you 3 marks lah, or even 5 issues to the point 5 issues in which one issue they will give you 2 marks. You must do the calculation inside your heart. Okay, so my answer is this. This question actually invites you to discuss what we call as right of audience. That means to say, anyone can appear before the court, before a judge, to represent and speak on the behalf of a client or not. This is what it meant. Okay, so we have to go to the specific provision of Legal Profession Act. That is Section 35 sub rule 1. I do hope that you have this LPA with you. You can have a look. Section 35, what does it say? Okay, so it said that right of advocate and solicitor, and it sounds in sub section 1 like this. Any advocate and solicitor shall subject to this act and any other written law. You see, you read this provision carefully, have the exclusive right to appear and plead in all courts of justice in Malaysia according to law enforced in those courts, and as between themselves have the same rights and privileges without differentiation. Okay, so this is to say any advocate and solicitor can appeal and plead. That means to say they can raise their voice lah. They can go to trial. They can go for case mention, etc. Uh, before the court, and regardless of whether they are senior, junior, whether they are coming from overseas, those called into the bar or pass CLP exam, or those who have passed local university exam, we are the same, okay? So, is it always true? The question invites you to say, advocate and solicitor, what do you understand by advocate and solicitor? We only call ourselves as advocate and solicitor when we are in private setting. I hope you do agree with me. If you are working with somebody, a multinational company, well, not just multinational company, any company, you are deemed to be in-house counsel. By right, if you are not intended to practice as an advocate and solicitor, sorry. So that means to say, you are just wanted to do some legal counsel works for big corporate. Actually, you cannot apply for CJR annual, okay? And if you are working with government, for example, you are called as, if you are working with judicial legal services, you may be a magistrate, or you might be this DPP, Deputy Public Prosecutor, or if you are working with some sort of what we call ministry or EPF, you are federal counsel, So that is to say, you are not strictly speaking an advocate and solicitor. So how do we go deep into this question is we have to look at this famous case law, Perbadanan Kemajuan Kraft Tangan Malaysia against D.W. Margaret. Okay, so now the big question posted to federal court is in such, because for you to go into deep this sort of statement, you have to argue with good knowledge in it. You cannot simply base on your general reading, It must be backed up by a classic or landmark case law. So the court was asked, whenever there is a conflict in between Section 35 LPA, because Section 35 generally govern all the advocate and solicitor, but this issue arise because the Latin lexim said that generalia specialibus non derogant, specific provision of the law must have overriding effect over a general rules. LPA itself is a general rule whereby this Perbadanan Kemajuan Craft Tangan, the handicraft corporate, is specifically governed by Perbadanan Kemajuan Craft Tangan Malaysia Act 1979. Okay, so now, this Perbadanan Kemajuan Kraft Tangan wanted to sue P.W. Margaret. But then by right, according to this Section 35, they have their own federal council. That means to say, I already said to you lah, just now, any semi or any governmental sort of corporate like EPF, BSN, all that, they have their own legal team, you know. So the question put forward to the court is only A and S, advocate and solicitor, can appear on behalf Perbadanan Kemajuan Kraft Tangan in front of the court. So, but then somehow they have their own counsel. So how? The locus standi issue come opens. That means to say, I challenge that. I'm the opposing counsel. I'm acting for DW Margaret. So I challenge the other side lawyers has no locus standi. So this is how this argument comes about. And this case actually has the chance to go to federal court because the objection was actually overruled in High Court, but then agreed by Court of Appeal. So you see, whenever there's something issue like this, High Court, okay, said no. Court of Appeal say yes. Subsequently, there's a gap of the differences in opinion, you know. Okay, so this issue of interpretation, how do we construe Section 35 goes to all the way to federal court. So this case quite interesting. Okay, so whether plaintiff could engage private solicitors to act for its civil proceedings or not. So by virtue of Section 35 LPA, and also whenever it has conflict with Section 35, this is a specific act for Perbadanan Kemajuan Kraft Tangan. So you might see this issue not only just in this Kraft Tangan thing, but EPF also sometimes got. Okay, and in another case of Lim Guan Yin against Ruslan bin Qasim, okay, but this small case law is pertaining to defamation suit. Now the thing is, one party actually is acting like government public officer. Okay, for example, I'm the Minister of Finance, and then I was being defamed on my public duty, say that I'm a lousy finance minister. I ruin the economy of the country. So by right, who should I call to sue that person that defend me? By right should be my ministry legal teams, right? But the thing is, can I do so by the virtue of Section 35 LPA? Because it said that only advocate and solicitor is given exclusive right to appear, plead in all courts of justice in Malaysia. Okay, so this is how. If I call my federal counsel to represent me, other people, I mean, the opposing counsel will say that, oh, this federal counsel actually cannot act. But is it really the interpretation of the this Section 35 provision? So actually, it's not. Actually, it's not. Please go to Section 35, Subrule 2, your A, B, BA, and C. Okay. So apart from advocate and solicitor, who are mostly, all of them, advocate and solicitor must be private practitioner. Okay. Apart from private practitioner, who else can actually go in front of court and argue their facts? Legal officers. Okay. If you see your subsection A, legal officers. B, the Amanah Raya Berhad officers, okay, DGI, the Director General of Insolvency, that will come from your Jabatan Insolvency. They will have their counsel as well, okay, and Director General of Legal Aid as well. So these are the officers that come into the exclusion. That means to say A and S is not the exclusive species that can represent parties in a lawsuit. Okay, bear that in mind. And if you look further, your section 38 38. Where is it? Okay. Certain person can act as advocate and solicitor. So if you are reading the subsection 2A, B, B, A, C of section 35 LPA, together with your section 38 of your LPA, you give rise to an equation that not only advocate and solicitor can appear as the person that have right of audience. So please bear in mind. Okay. So by this context, anybody that has been conferred by any written law by right can act for uh, a party in the court of justice. So they actually stretch how to say this is not stretching the legal interpretation, but this is actually um is a plain and ambiguous interpretation of the subsection 35 together with your section 38. Okay, so remember two cases, the Perbadanan Kemajuan Praftangan, as well as your case of Lim Guan Eng. If you put somebody famous, like Anwar Ibrahim, Lim Guan Eng, Najib, sometimes you will hit, because their case usually complex. Okay, and because they have means and resources, they are represented by very smart lawyers in Malaysia. So a lot of issues will arise. Okay, not just pertaining to evidence and their own crimes. Sometimes a lot of collateral issue. Okay, you can use. So if you read together all the provision that I have said, you must make conclusion. So what is your stand? What is your ultimate conclusion by the given statement? So you must submit that this statement is not right lah, because other officers, legal officers, as stated in LPA, can also appear. So advocate and solicitor is not the only one, not absolutely exclusive to appear or plead. Okay. Okay. Question B. Sam has graduated with the degree of LLB from University of Malaya. He is a qualified person under Act 166, but is not an authorized person under the said Act. Discuss the above in the context of an advocate and solicitor under Act 166. Again, this is an essay question that invites you to elaborate what is your understanding, what is your appreciation of the meaning qualified person as well as authorized person. Make a distinction. Okay. So if you look at section 3 of the Act, mean LPA, you can see that, I hope you don't mind just to flip to section 3. Okay. If you can see, qualified person means anyone that passed final exam leading to degree of Bachelor of Laws of UM or UM Singapore, University of Singapore, or NUS. So this is by meaning of section 3 sub rule A. Okay, if you agree, so Sam will submit so by virtue of this interpretation clause, Sam is a qualified person. Okay, use a very specific one and do not go further by saying that Sam is barrister or whatsoever. It's not necessary. Okay, it follows that if you are a qualified person, it just means that you are ready to call to the bar. It doesn't mean that you can practice as a lawyer. You agree with me? Okay. If you are interested further, you can go little to do a bit legal researches about this issue. There were some cases lah, but I prefer not to name this case inside this article. It's not nice lah. Somebody that with a third class LB certificate, I mean their degree is a third class pass, so they did not achieve the minimum requirement of LPQB in order to become a qualified person. Actually, there were a lawsuit ongoing. So that means to say you must be qualified person, then only you can undergo pupillage by virtue of your section 11, okay, of LPA. So please remember, this is just ticket for you to enter the door. But how you play the game is up to you. Eventually, to become a lawyer or not is subjected to the requirements set by your section 11. Okay, section 11, all the sub rules must be fulfilled. Okay, so you use a little bit fancy words lah. So at this juncture, sometimes I use fancy words so that you can follow, and sometimes for those who are not so familiarized in writing, you can use some uh, Pasmalam words as I have provided. So you have two options. Okay. So qualifications for admission. Subject to Section 14, a qualified person may be admitted as an advocate and solicitor if he is 18. 18 years old is a minimum age. So good character. Good character is something to do, something is subjective. Okay, because eventually, during our petition to be admitted as a advocate and solicitor, which I had just recently done, we need two referrals, from professional. That means to say they must be uh, teacher, accountant. I choose two of my senior doctors' friends lah, to hold the standing that I'm a person with standing in the society. That means to say I am a good person lah. Okay, so this is one of the thing that is subjected to Section 11, and you must free of conviction. Okay, free of conviction does not mean that any conviction somebody had committed drunk driving or some road traffic offenses, they can still get admission, provided it's not some crimes that has to do with the honesty thing. For example, forgery, you commit fraud, CBT. These are the grave crimes that you might get barred. By whom? The AGC, the Jabatan Peguam Negara. They'll have your criminal record one, and you must not be bankrupt. And one of the very important point here, you must get a certificate from LPKQB to say that you are not you are exempted lah from Bahasa Malaysia qualifying examination. If you are not having a SPM Bahasa Malaysia, probably you'll need to sit for their so-called Bahasa Malaysia qualifying examination. I heard this is quite tough, huh? Heard because one of my legal aid clinic friend did sit for it. Okay, and furthermore, you must not be disbarred. Disbarred means somehow you have been a, a barrister in some other countries, but subsequently the bar council or the legal society of that particular country had already suspend you or struck you off from the role. That is called disbar. And you must be a federal citizen or a PR of Malaysia. And of course, you must serve a 9-month pupillage unless you got exemption. Okay, and start from 1984, I think all of us need to undergo this exemption from Bahasa Malaysia. Okay, otherwise you need to sit for a specific examination. Okay, so this is about qualified person. Moving on, we have to discuss the next part of the question. That is, what does it mean by an authorized person? Actually, if you are looking as a whole of your statute, there's no interpretation about authorized person at all inside this legal profession act. However, you can infer, you can adversely infer, because Section 37 Sub-Rule 1 did provide for unauthorized person. Okay, so you reverse engineering. That means to say, by looking at how this unauthorized person act, will be guilty, etc., with a fine or imprisonment. So you look at the meaning of authorized person, supported with your case law. You use the case of Diljit Kaur or Darshan Singh. This is the favorite. I would say this is classic case. Okay. So for you to be an authorized person, okay, your name must be available on the roles of advocate and solicitor. Okay, that means to say, High Court of Malaya itself will keep a so-called list, name list, recording who had been called to bar. For example, if I was recently called to bar just a few days ago. Okay, you need to give an instrument, instrument that's it looks like a certificate, and then you have to give to the registrar of high court for them to keep so that they can register Ji Hui Bing, so and so, date of admission to bar 26th of October 2023, something like that. So this is one criteria, role of advocate and solicitor. Second thing, for you to become a lawyer, role of advocate and solicitor itself is not adequate. You must have a valid practicing certificate. We call CJR annual of the year. That means to say, if I wanted to practice tomorrow, but I have not obtained my CJR annual, by right, I cannot. I cannot. I don't have the standing. I don't even have the right of audience in front of court because I do not have that seizure annual. So this is pursuant to your section 36 sub rule 1. Okay. And for those who few who are having some lecturers, sometimes you read their name is a little bit uh, kind of you'll feel amazed, and sometimes you will feel a bit of confusion. Why is it so? Sometimes they write non-practicing advocate and solicitor. I'm sure many of you notice lah, some of the lecturers or those who are in academic. So that means to say, once upon a time, there were actually practicing lawyer with valid seizure annual. But subsequently, for example, next year, I wanted to switch back. I just, wanted to have a feel to become a lawyer for 2 months. Okay. Uh, uh, November, December, I got my seizure annual 2023. 2022, for I don't want to apply. I want to go back to medicine, take for example. So I can label myself as non-practicing advocate and solicitor. So every year, every year, the bar council will actually send a list of the person that did not have seizure annual of the year to registrar of high court. Okay, and it will be forwarded to all the members of the bar as well. You get me? So this is how important uh, you must have authority. You must be an authorized person. Reason being is very simple. If you do not deem yourself, or you do not actually uh, is a truly qualified, is truly authorized person, the whole proceeding that conducted by your good self, for example, you are a non-authorized person, is null and void, That means to say it has no legal effect, So a bit difficult, and it will make the whole judiciary system and also the bar looks very bad. Okay, look very bad. And persons or bodies, okay, so this is again the registrar also issued, but actually it's the same lah, seizure annual practicing certificate. But they sort of bar issue the seizure annual, they lies with the registrar of high court. So everybody with valid seizure, sorry, non valid non the CGL annual of the year, the list will be sent to the acknowledgement of High Court Registrar. Okay, so as simple as that. Please highlight these four important points to be an authorized person. Okay, so this is all extracted in case law. And if you have non-practicing, yeah, the name is still on the roll. So long you resume back to your practice within 6 years, it's okay. This question I have checked with Bar Council already. Okay, so if you look at the case of Bar Malaysia against Index Continent Sendirian Berhad, so actually, Malaysia Bar is suing this particular company for being an unauthorized person. The brief fact is very simple. This index continent is trying to promote a scheme, it's like a subscription scheme, That means to say you prepare the legal service, you get a gold package, platinum package for paying nominal fee, like 900 plus, and then subsequently, their engaged employees will actually provide you legal services. So somebody lodged a complaint to Bar Council sue this company, Index Continent. So they define unauthorized person in debt lah. Okay, and another case that you should look at is Bar Malaysia against HF Vitality Sendirian Berhad. Okay, in these two cases, so the the Bar Malaysia had actually sought for a declaration about the meaning of what does it mean by an unauthorized person, okay, as well as an injunction to prevent the defendant from providing similar services as such forever. So that is a permanent injunction granted by the court. Okay. So this is what it meant. Uh, Actually, to be how to say, this authorized person is not just going to court thing, So providing legal advices, drafting documents, some non barrister thing lah. That means to say it's not litigation thing, a non contentious matter or litigation matter are all classified as legal services. Okay, so this is very strict interpretation. Only advocate and solicitors will be deemed as authorized person. Eventually, the court decided in favor of Bar Malaysia for both of the cases. Okay, the HF vitality as well as your index continent Sendirian Berhad. So your conclusion, after saying so much, you must give your stand. What is your ultimate opinion about this statement? So you must say that you agree, she is qualified. But being a qualified person mean that she could call to the bar. She cannot practice law okay, until she fulfill the meaning to be an authorized person, okay? And Sam will need to go pupillage and fulfill other criteria of Section 11 LPA before she can claim herself to be an authorized person. Okay. So next question. Hong study and obtain qualification in university in Australia. Okay. He has been practicing in Malaysia for 10 years and is operating his own firm under name and style of Hong Associates. Hong now wishes to engage a lawyer from Australia specializing in international corporate law to join his firm. Last few years, this was a popular topic because with the amendment of 2014, so actually liberalization of legal services happen in Malaysia as well. So Malaysia law firm, if you are big enough, of course, you can actually hire foreign lawyers or build an international partnership with others. I mean, with other law firms in United States, for example, UK, for example. Okay. And the first question actually asks you to discuss the process on how to employ a foreign lawyer. Okay. And you must look at the provision under legal profession, licensing of international partnership and qualified foreign law firms, and registration of foreign lawyers rules 2014, as well as your section 40H of LPA. Okay. So this is a quite a complicated procedure. If you are not familiarized, if you are just having this LPA with you, better don't do. This sort of question, if you are not very sure, don't do. Okay, please do other question first. Then if your other remedy is exhausted, then you come back lah, no choice. Okay. So a Malaysian firm can make application for a license. This is a license to employ foreign lawyer, like a visa thing like that. Okay. In Form Cs of these 2014 rules. And then you must know that only 30% total number, let's say I have 10 lawyers, that means the number of foreign lawyers should not be more than three. Okay. And subsequently, permitted area, only specific areas practice and very limited lah, actually. So areas of law, which is constitutional matters, administrative law, the SPA thing, criminal laws, family law, all you cannot practice. Cannot, okay? Cannot practice. And the said foreign lawyers cannot even appear in the court of justice or any tribunal. For example, the MMC, the Malaysian Medical Council, industrial court, all that cannot. Okay. And the foreign lawyer cannot be simply anybody, but they must have legal expertise and experience in a so-called specialized area. And the foreign lawyer also must make application under Section 40J in order to register themselves as a foreign lawyer. Okay. So this is the application fee as well, 5,000. Okay, this slide will be distributed. Okay, don't worry. And the Tong and associates in the question must buy mandatory professional indemnity insurance to cover. Okay, um, look, the coverage, I think, is reaching 5 million, because usually, like I said, the small firm usually will not engage the services of foreign lawyers, usually multinational. Um, I mean, those law firms that is so big enough that deal with multinational companies, they need to be familiarized with international trade law or the what we call maritime laws. These are the law firms that will be requiring engagement of foreign lawyers. Okay, so quite expensive, huh? And eventually, the Bar Council, after the selection committee meeting, all that, they'll issue a license in Form F. Okay, and such license will valid for about 3 years. Okay, and the lawyers must apply for practicing license just like us, okay, but they are under this specific provision, okay. And what is the question two? Discuss to what extent the laws, rulings, and directive applicable to an advocate and solicitor under Act 166 relating to professional conduct and ethics apply to foreign lawyer from Australia. Okay, you just think behind the why this provision, I mean why this ruling is needed. Because usually if you want to get uh liability suit, that means to say if you are acting negligently in one case, usually of course the law firm will be sued, but the apportionment of damages will be particularly high on the lawyer that is negligent. Like, for example, I'm a partner, one partner inside my law firm, Chris and Partner. So I will be named as first defendant, Ji Hui Bing. Second, Chris and Partner will be named as what we call second defendant. Eventually, if let's say I was negligent, probably we are looking at 90% the whole damages, like quantum that is awarded by court, 1 million. 900,000 I have to come from me, you know. So you cannot allow a foreign lawyers that can practice just like that without any professional conduct or ethics ruling binding on them. So I hope you agree with me. So under this legal profession, licensing of international partnerships and qualified foreign law firms and registration of foreign lawyers rules 2014. So a foreign lawyer shall apply for a bar council for a certificate of registration in Form G. Okay, and then the foreign lawyer should be just like us lah. You must have good character, but you do not know whether they have good character or not, isn't it? So you must have good reputation, and there is some specific jurisdiction that you can hire the foreign lawyer. You cannot hire somebody from Israel, Palestine, for example, or South Africa. Okay, there are actually some countries, you know, that the foreign lawyers can come from. For example, Asian countries usually lah, because we have this Asian uh, this society, isn't it? So almost all Asian countries, foreign lawyers, they can qualify to practice in Malaysia as foreign lawyers. Okay, and jurisdiction whose universities are recognized by LPQB, that for example, UK, Singapore lah, okay, New York Bar Malaysia, and this is one flexibility. Other jurisdiction as the Bar Council may approve from time to time, because it takes such a great deal to pass a law. So that's why they will have some room of flexibility from time to time. Uh, so take for example, we are seeing China to be a growing economical power. So somehow or rather, many Chinese investor may come to Malaysia, and eventually we might be requiring Chinese lawyer, the real China lawyers lah, to come in to advise us as foreign lawyers. So this is one of the example. So permitted areas only are very important. And the foreign lawyer must be having such expertise and experience in that particular area. Okay, for example, international corporate law. Okay, so so the foreign lawyer is also required. Okay, so the to answer that question, we are looking at Rule 7 of the legal profession licensing of international partnership, or such a long name, you see. So all the rules listed down in Rule 7, the LPPER, the Legal Professional Liability Insurance Rules 1992, Legal Profession Disciplinary Proceedings Appeal Rules 1994, LPPR 2001, Advocate and Solicitor Disciplinary Inquiry Procedure, Advocate and Solicitors Compensation Fund. You see, most of us will only hear LPPAR as well as LPPR. Actually, there are so many to have existed. Okay, the Solicitor Accounts Rules 1990. I think this one you will be familiarized. And this one, Accountants Report Rules 1990, and all others stated inside Rule 7. So this is what it meant by to what extent, okay, that the rules should apply to that particular foreign lawyers. Okay, so in regards to say all the rules that almost exist that by the conduct of advocate and solicitor in Malaysia will have the same effect towards the foreign lawyers. Okay, as simple as that. Mm. So you submit lah. Conclusion. Foreign lawyers shall be subjected to any rules or laws imposed to local advocate and solicitor. For example, LPPR, LPPR. Okay. And third question, I think this is much more doable as compared to the previous two. Salma, an advocate and solicitor, has been practicing in Negeri Sembilan for many years. She is also politically well known and has made a name for herself amongst the rich famous. So this is good for her lah. Following a recent high-profile case in which she represented Datuk Sri Velu in a defamation suit, Salma called for a press conference at her plush new office. Prominently displayed outside Salma's new office was a gold-plated nameplate measuring 100 cm by 80 cm. So fully attired in her court robe and with Datuk Sri Velu by her side, Salma briefed the journalists on the whole case and posed for photographs with her client. The full interview and photographs made headlines in all leading newspapers the next day. Best lawyer in town. So every person virtually present at the press conference was given a copy of brochure, Salma and Associates. So on first page of the brochure were the words, experts in intellectual property and defamation, and photographs of advocate and solicitors of the firm. So you are asked to discuss Salma's conduct in relation to LPPER and LPPR 1001. Okay, so in this manner, I afraid you have to memorize the specific LPPR and also LPPER ruling. Okay, you have to memorize because during exam you are not being provided with the said rules. You start with saying a very brief introduction, say that the misconducts done by Salma was subsequently you must go very specific and short and sweet. Do not elaborate much. General rules are the easiest to remember one usually is 16 and 31 of LPPER. It's about the dignity or about the reputation of legal profession must be upheld. So anything, any misconduct that bring shame and what professionally malu will affect the dignity of the profession. So this is a very good starting. He had brought shame, Salma had actually brought shame to the profession at large lah. Okay, and you use Rule 4 LPPR, the publicity rule, said that a lawyer in practice should not solicit publicity. So this is a very general one, you know. It means to say you cannot purposely, for the purpose of publicity, you do this thing. Cannot. Okay. And Rule 15 LPPR, I go chronologically because starting with a press interview first. Rule 15 publicity rule did not say that it is compulsory for an advocate and solicitor not to conduct any press interview at all. Because sometimes we do need to give some comments, okay, about legal views, right? Otherwise, the judge themselves are not allowed to. Who else? You cannot resort this issue to lay person, right? So there is always a flexibility. But the case law said you should try to avoid giving press interview because before the trial ends, any this sort of press interview or any comments might have a negative impact, or you actually use the public, you know, to push the court to achieve a certain outcome that you want. For example, the case of PP against Sam Kerting. I'm sure you know the Basika Lanjak case. So a lot of comments before the appeal. I mean, so many said that she was actually not guilty. But just by, just saying without any substantial evidence, So yeah, I mean the judge themselves also read newspaper and also probably will have a social media account also, right? So you cannot use the press or the freedom of expression to influence the decision of the judge. So sometimes it will call as a sub judice comment. Okay, you refer to the case of Chia Yok Pong here. And even if, let's say, the case had been decided and then the decision had been hammered on the day, and a lot of newspaper fellow comes now, oh, what is your comment about the decision of the court? Oh, just because that you feel that the decision is in favor of your client, you go and say that. I think this decision is very fair. It shows that Malaysia judiciary system is still workable like that. But somehow or rather, you had create a scandal, among the court and also the judge. Uh, other way would be if, let's say, the case is decided not against, against your client. For example, one high profile case whereby the bail amount is very high, too high, and then that particular lawyer made a post decision conference saying that, well, the bill so high, even I cannot pay. How could the judge raise, this sort of amount of this, the bill amount, something like that. It will actually amount to scandalizing the judge or court. So do that, be cautious. Okay, do that, be cautious. And Rule 9 of your publicity rule, as well as your Bar Council ruling 2019, Chapter 2, specifically provide for the nameplate, your signboard. Okay, it must not exceed 92 times 61 cm. And you must use black, usually from what I have seen, it's only black and white. You cannot use it. For example, I'm a person that love red color. You can see from my slides, most of them are red colors. So I cannot put, Chris and partner, red color, big, big. It's not allowed. Okay. So gold-plated and oversized nameplate will infringe the rules. Okay, you submit so. And Rule 30 LPPER provide that you can actually wear robe in the High Court, Court of Appeal, or Federal Court. Okay. In the circumstance that I have observed, very rare lawyers will actually wear robe in the subordinate court, left alone in public. You cannot do so. Okay, you cannot wear in public. Okay, for example, just because I have my long coat already, suddenly I'm wearing a robe, okay, robe and also a bib with me when teaching you. It cannot be do so. Okay, and Rule 48, advocate and solicitor are not allowed to publish photograph for personal advertisement. Okay, very important. And Rule 15, best lawyer in town. Yes, Rule 15 allows for press conference, but you will need to look at a case-to-case basis. In the case of Samas, apparently the so-called best lawyer in town thing is not a genuine interview, but rather a disguise for her advertisement campaign. Okay, so the bar council is quite smart. You cannot just put, okay, for example, I know I cannot advertise in newspaper. Subsequently, I use a loophole. Put vacant position. Okay, I said, oh, I want to hire people. So I put at the front page of Sinchu. Can like that. So it's a disguise. What actually I don't want to hire any people. I just want to advertise. So cannot. Okay. And Rule 5, sub rule A and B, advertise can be allowed, but not lower the dignity of profession. So sometimes if you Google around lawyer near me, medical legal lawyers, okay, for example, you can see the sponsor link inside Google. So actually this is allowed so long you did not exaggerated yourself to be number one or legal 10 in Malaysia, something like that. Okay, and you cannot claim specialization. You can only put area of practice, rule 6 publicity rule. Okay, the rationale behind that, not every lawyer, for example, me, I cannot do some cases, certain cases I have no knowledge at all. Insurance law, I cannot do. Maritime law, intellectual property, I do not have sufficient knowledge. So there's no reason for, if let's say I do not put my area of practice, I'll put medical legal, yeah, because my background, I'm familiarized. This is my area of practice. So takkan every call I have to reject them, right? So I specify my area of practice. So this is allowed, but not specialization. Okay. So rule 12, publicity rule, you can actually print some brochure, but for educational purpose inside your law firms. Reason being, clients will come and seek for some legal opinion, but after 1 hour of pitching, usually the client will left with 5%. Sometimes the lesser, I mean the poor memory one will come back with 3%. So there is a need to provide some information, written information to them. So this is allowed, but not photograph and for advertisement purpose. Okay, this will again infringe your Rule 48 LPPER. So sum up everything. Some conducts had actually amounted to breaches of LPPER and LPPR 2001 rules. So this is actually a misconduct under the meaning of Section 94, Sub-Rule 3 and Sub-Rule O. Okay, so this is your conclusion. Should be subjected to disciplinary punishment. Okay. Next, we go to Karim is an advocate and solicitor of more than 20 years standing, maintaining a very busy litigation practice in KL. He has refused to employ any legal assistant and hence has to attend to all court matters all by himself. He has now decided to open a branch office in Seremban, doing mainly conveyancing work. He has engaged a retired clerk, Mala, to maintain the day-to-day administration of Seremban office and to attend to clients come to seek consultation. He only attends this Seremban office on Thursday. Karim divides the fees and profits from all cases with Mala on 30-70 basis. Okay. So Karim has been running a family business earlier, managed by his father, now retired due to ill health. This reflexology business has been very successful and has supported Karim and his siblings through their studies overseas. He intended to continue the business as the income has been good. So Karim dropped in and at the business premises at least once a day. As a result of all these busy activities, so Karim was very tired and often late in court. So on one occasion, he arrived at the court to find that the court would not grant a further adjournment for hearing of the case in which he was acting for the defendant, and the court had awarded the judgment to the plaintiff. So you are required to discuss Karim's conduct in relation to LPPER. Okay, 10 marks. Again, this is another way to show to you how to answer. Just now, I put it in chronological order. This is also can, but my preferred way will be heading. Okay, first, you tell the examiners what happened. You use your own word to draft a simple heading. I will submit first, busy all day long, late, no attendance or no preparation. Okay, so you submit your law, section 6 of LPPER. The advocate and solicitor should be ready to appear in court and handle case. And he should always be ready for trial. Section 24 LPPR. The case to support these two, you can use PP against Muhammad Najib Razak. Okay. And second heading, engage Mala. Is there an issue? So Mala is actually an unauthorized person because she was just a hot clerk. Okay, she was not the person that the name inside the advocate and solicitor role, no valid seizure, annual, etc. So Rule 51 LPPER specifically said that advocate and solicitor cannot engage a lay person to see client to secure a case or business. Okay. And 52 rule said that you cannot share profit with non-qualified person. Okay, non-qualified person, qualified person I already told you by meaning of section 3 LPA. Okay, if you are somebody that wanted to raise the question of law later on, okay, for example, a person that grads with LLBUM or a CLP person, can you share profit with him even though he or she does not have seizure annual? So this is a very good question to post it to you, But anyhow, Mana is not a qualified person, lah. Okay. And Rule 59 LPPER, as well as your BC ruling, Chapter 7.01, it said that if you open a branch office, take for example, my firm wanted to opens a branch in Batu Pahat. So I have to go to the Batu Pahat office and manage it accordingly. So I cannot stay in JB, remotely control the Batu Pahat branch. You must be managed by an authorized person, very important. So next issue will be reflexology. Okay. Again, you use the general rule. It will not go wrong. 1631. That is the dignity of the legal profession. And then subsequently use this Rule 44 of your LPPER said that advocate and solicitor must not actively carry on any threat. Okay, the word is actively. Okay, and also threat that is not compatible with legal profession. Okay, for example, I have a food and beverage business, side business, but it does not require my physical attendance. Okay, I'm just a shadow director and also substantial shareholders. Actually, in this sort of case, you can do so by written consent from bar counsel. So long the business does not sound a bit one kind. You get what I mean, isn't it? So reflexology, um, and one case law pointed out acupuncture, all that, it give a negative impression to the legal profession at large. You run a pub, for example, a disco. So, people will say, this pub or disco run by a lawyer. So people will associate you with this sort of business. So somehow or rather, the bar itself will not be so happy. Okay. You can use the case of re and advocate. This is a classic case also. And BC rulings, chapter 1201. It could be incompatible with the dignity of our legal profession. Okay. Adjournment. So causing judgment in favor of plaintiff. So rule 6, rule 24, LPPR, as discussed, you use again. And furthermore, the said person, Ali, might also be liable for professional negligence because he had failed to act according to the standard of care, okay, of a reasonable and prudent advocate and solicitor. Okay. If you acted like that, I think sooner or later you'll get your license revoked lah. Okay. So disciplinary action will actually follows lah. This is by section 94 subrule 3 LPA. Question 4. Okay. Chong, an advocate and solicitor practicing in the name and style of Messrs. Chong and Co., acted for CD in a sell and purchase transaction. So CD was the vendor in the transaction. The purchaser had paid the full purchase price to Chong for onward transmission to Sealy, so holding the money as stakeholder. So the sale transaction was completed, but Chong failed to release to Sealy the amount received from the purchaser. So Sealy had on numerous occasions gone to Chong's office to collect monies received by Chong, but was told by Chong that he was not free to attend CD. It seems that Chong is trying to evade uh, to see this CD. And CD became annoyed with Chong for not releasing the monies and lodged a complaint with the disciplinary board under LPA. So number one, you are required to state the various stages of any disciplinary proceedings that may be commenced against Chong. Okay, so the question asks you to state stages. Okay, so how does it work? When CD lodge a complaint, how does it work? So the governing proviso will be, of course, the main one will be your LPA 1976, but subsequently you also have this legal profession disciplinary proceedings rule 2017. So the stages will be like this. CD will need to make a written complaint. Okay, written complaint, very important. Cannot just call by phone and say that, oh, Chi from Chris and partner committed this fraudulent activities on me. Okay, run away my client's account's money, for example. You cannot just by WhatsApp or call. You must write in. If payment 200 ringgit, and also sometimes statutory declaration is required to support this complaint. Okay, section 99 LPA. And subsequently, the secretariat open receive this written complaint, provided it is compliant to the rule. I said to you, written got a statutory declaration, and somehow you must pay 200 ringgit. So all these rules compliant, then the complaint will be lodged inside the complaint register. So this is by your Rule 7 sub Rule 6 of legal profession disciplinary proceedings rules. Subsequently, what happened? There will be an preliminary investigation by disciplinary board. They will see this complaint has got merit or no merit. For example, the cases when there is no merit will be the complaint was actually made lapsed the limitation period 6 years ago. The allegation was about like 7 years plus. They want to raise back the issues because probably the relationship turns sour. So they will dispose the matter if there is no merit, no investigation at all. But if there is a merit, the case, the DB will initially write to the uh, the advocate and as solicitor to ask what is your side explanation? What is the explanation on your part? What is your comments about the complaints lodged against you? Okay, so this is section 100 LPA. Eventually, after the so-called the return, the correspondings and everything, if let's say, for example, DB feel that the case can be settled among the parties, it's just a dollar and cent. For example, there's a late in filing, for example, and then impose some penalty to the to your plaintiff. I mean the client's complaint on you. The DB will actually ask you, you want to settle or not, you just pay on her behalf lah, just settle. So it could be summarily disposed the case. Okay, bear that in mind. But if the case is cannot reach settlement, or the case itself is too much, so much so, I mean, impropriety is there, the culpability, and also the degree of harm of that particular case that warrant further appointment of a disciplinary committee, or that means to say probably you are in some kind of problem. The matter itself is already a quite serious one. It's not just a trivial matter that you can settle the B. Okay, so this is by section 103A LPA. So appointment of disciplinary committee. So the disciplinary committee usually will be formed by 3 person. Usually will be having those who out of them will be senior lawyers with at least 10 years standing, okay, in the profession, very senior person, and subsequently they will conduct investigation. They will also conduct inquiries. That means to say they will call you, they will also call the complainants. It's just like the trial process. You can have examination in chief, cross-examination, and subsequently re-examination. All the evidence can be tendered during this DC meeting. After finish all the investigation, DC will be required to write a report to DB, disciplinary board. Okay, disciplinary board will they'll have to read what are the reports all about. They can act accordingly to the recommendation of DC, or they can reject the recommendation by imposing their own decision. So um, it is not, it is at their discretion, that means to say, okay, so these are the stages of your complaint. Okay, so starting from section 99 and end with section 103D. And then you must put in this legal profession, disciplinary proceedings through 2017. Okay. And second question, state the punishment that can be imposed against Chong in the event he is found guilty by the disciplinary board. So what are the powers that given to DB? It is also being found inside the provision. Section 94 subrule 2. If you have a look, section 94 subrule 2 actually provided A, B, C, D. Okay, be very clear. The most serious and the grave one to a lawyer will be struck off the road. That means bye-bye. No, you can no longer practice law. Okay. Second, suspension. You have to stop temporarily for practicing up to 5 years. C, order to pay fine. Okay. This is a spelling mistake. Not more than 50,000. And D, to be reprimanded or censured. That means you are given warning. But this warning is not something that is funny also, because you are on record. First timer, they give you a warning. Second time, the penalty will be severe already. So better off not to have any record lah. Okay. And additionally, if you look at section 103 of your LPA, and if you are type that is careful with your career, I would advise you to look at Bar Council website, official website. Every month they will have disciplinary order announcement. And virtually what I'm seeing is every month got people being punished. Okay, so very important. Okay, obey the rules lah. And section 103 LPA, effects of DB's order of fine or restitution. Okay, restitution means because all this ABCD does not have a clause to order Chong to pay back Sealy's whatever the money that Chong is holding as stakeholder, right? So this section 103 provide one more one more room in which the bar council, the disciplinary board, can order restitution, meaning to say that Chong has to pay back whatever money that is due to CD. Okay, and we look at number three. What is Chong's right of appeal, if any, in the event he is found guilty? Okay, so if you are found guilty, your right is stipulated inside section 103E LPA. And in fact, there's another appeals, legal profession, disciplinary proceeding, then bracket appeals rules. Later I add in. So you have actually rights to appeal within 1 month to High Court by OS and affidavit. So the hearing will be in front of one High Court judge, and then further appeal, you can go to Court of Appeal if you're not happy, and ends in federal court. And bar counsel can actually intervene. That means to say they can pencela lah. They can add in as intervener. Okay, and DB cannot be cited as party. BC also cannot be cited as party. You must cite Malaysia, Majlis Peguam Malaysia, okay, Malaysian bar. But if in the event if Chong is ordered to be struck off, suspended, appeal actually does not operate for as a stay for DB's order. The order itself, if you read lah, any of the announcement from Bar Council, you have 21 days to pass over the duty, and the said order must be executed. No stay on appeal. Okay, get the point very clear. Huh? I think due to my throat, please allow me a break of just 1 minute for me to drink water. Then we come back. Okay, 1 minute. Okay, I'm back since I think all of us, your time is particularly precious. I do not want to go too long also. So Malcolm was admitted as barrister of England and Wales in 2008. He then stayed on in England, working in an alternative dispute resolution consultancy firm, specializing in arbitration. So in 2019, Malcolm actually came back to hometown Ipoh and set up MALADR Chambers and styled himself with the title Arbitrator Advocate Senior Counsel. Okay, so what happened next? Felix Gunn, a property developer, agreed to appoint Malcolm to act for his stable of companies now embroiled in legal proceedings, including appeals from Sabah Sarawak in the Court of Appeal and Federal Court, and that will likely be sitting in Putrajaya. Arbitrations and adjudications in Sabah as well as Sarawak. So Malcolm had issued invoices for which the companies controlled by Felix Gunn had paid a total sum of 1.5 million as fees, and a further sum of 1 million is due for payment. So Felix now discovered that Malcolm has never been admitted as an advocate and solicitor in Malaysia, and was advised by his clerk that Malcolm is an unauthorized person. He confronted Malcolm, who asserted that as an arbitrator advocate, he can practice in Malaysia, and there is no necessity for him to be admitted as an advocate and solicitor. So Malcolm also stated that Malaysian bar has no authority over him, and that his fees must be settled immediately. So you are to advise Felix Gunn on the following. Whether Malcolm assertion, okay, on his right to practice is curate. So to answer this question, so you have to go through the facts one by one. I think we have one question coming in. If the complaint is okay, the if the complaint is withdrawn, uh, the disciplinary boards can still continue to investigate the matter. Okay, so famous case Chong Yik Sen against Majlis Peguam, Malaysia. So this is the account that I've learned from my friends. Mr. Chong was a very famous lawyer, but unfortunately, due to his personal matter, he had acquired some of the fund from clients' account, and then subsequently just to pay for the medical bills, and then eventually he top up that money and then settle with the client. But since the complaint was already lodged in Bar Council in the disciplinary board, subsequently the investigation went on and he was found liable. Eventually, he got struck off from the role. Okay, so back to this question, Malcolm is actually a barrister to England and Wales, Section 3B of your LPA. So he is actually a qualified person. You must state that. So qualified person does not equal or equivalent to an authorized person. And you have to submit that there is no factual evidence that Malcolm had fulfilled the criteria underscored in Section 11 LPA. So likely he's not authorized person under the Act. So you use Darshan Singh or Diljit Kaur against Majlis Peguam Malaysia. For example, he does not have role of advocate and solicitor and valid procedure annual practicing certificate. So he has no right of audience in Court of Appeal or Federal Court Malaysia. Yeah, Federal Court Malaysia. Even if he has so, he might have difficulty to represent the case coming from Sabah and Sarawak because Sabah and Sarawak, they are deemed to have separate high court. We are just lawyers acting for High Court of Malaya. High Court Sabah Sarawak separate territorial jurisdiction under CJA, and they have their specific Sabah law ordinance, for example, that govern their practicing lawyer. Lawyers from West Malaysia, Peninsular Malaysia, cannot just travel. Okay, I take a flight to Kota Kinabalu and open a branch there. You cannot do so. Okay, this is another issue that you can raise. But however, if you are looking closely, here the arbitrations. Okay, arbitration that is the one of the disputable area of law in which to say if you look at your Arbitration Act 2005 as well as your Section 37A, okay, LPA. If you look at Section 37A, if it is arbitral proceeding, you do not actually need to be an authorized person. So, if you do a little bit deeper after your exam, I mean, of course, if you read uh, the Justice Hamid Sultan's article, they have he disputed the constitutional effect of Arbitration Act. Arbitration Act can make a stay of proceeding of all trial, right? And some more, this section 37A, as well as the own Arbitration Act, impose that you don't need to be qualified as lawyer to go for to represent a party in arbitration. So is it something wrong with the interpretation of law? Okay, any interested party can contact me. I may have that article in me. And you conclude to say that Malcolm cannot call or label himself as an advocate and solicitor because he is not an authorized person. Okay, he's not an authorized person. Against, you can use the Index Continent Sendirian Berhad case or HF Vitality case. okay, to support your conclusion. Okay. So B, what is the status of the fees? Because Felix had already paid 500,000, so the balance 1 million. Okay, how about these two payments? How to solve it out? So you refer to your section 40, okay? Section 40, sub rule 1. Okay, I hope you can open up your section 40, sub rule 1. And no cost in respect of anything done by an authorized person as an advocate and solicitor, or in respect of any act which is an offense under sections 37 or section 39 LPA. Okay, that means to say Felix need not to pay that balance of 1 million by virtue of section 40 sub rule 1 LPA. And how about the 500,000 that had been paid by Felix? So by the subsection 2 of section 40, so that 500,000 payment is actually recoverable by Felix. Only thing is Felix need to commence a writ action against Malcolm. Okay, so I put it in session court Ipoh lah, because Malcolm stay there, hometown. And probably one more substantive law that you can refer to will be your contracts. Okay, that is section 24, illegal consideration. It means to say the whole thing itself, the agreement was actually on the basis that Malcolm is a qualified and authorized person. He is a real arbitrator and also what we call advocate, as he represented himself to be. But somehow or rather, the contract is tainted with the issue of illegality, so cannot be enforceable. So the parties need to restore the benefits received. Okay, so this is your answer. And C, whether the Bar Council may take any action against Malcolm. Yes, they can. Because as we have gone through the case HF Vitality and this Index Continental, so Bar Council usually will do what? They will sue Malcolm in civil action to seek for a declaration that Malcolm is an unauthorized person under Legal Profession Act. And also, they will seek for a prohibitory injunction. They will say to Malcolm, stop acting and stop representing yourself as an advocate and solicitor, ever and ever. Okay? And probably they will launch a police report also, because offense under section 37 sub rule 1 is actually punishable with 2,000 ringgit fine or 6 months imprisonment or both, it is a criminal offense. Okay, and second question, we look at Muna, an advocate and solicitor practicing as a sole proprietor of Muna and Associates has not been issued a seizure annual for year 2020 for the reason that she had failed to submit an accountant's report in her application. She is of the opinion that it is not necessary for her to submit this accountant report, since she had closed her client's account sometimes back, and ever since that, she had been operating in a way that convincing practice by putting all the money inside of his account. So Muna wants to challenge the decision of Bar Council in refusing to issue seizure annual. So one of Muna's client, Maj Mudar, had deposited with Munas and Associates a sum of 2.5 million ringgit as balance of purchase price, and has now sought the return of it together with interest on that sum, since the SPA was mutually terminated. So Muna claims that no interest is payable on the principal sum, and in any event, part of the sum has been set off against other bills that had been issued to Maj Muda's wife, and children for Muna's legal services and other venture, namely tailoring services. In any event, Mahmuda's wife had agreed to settle. So for legal services, Muna claimed that she had given to Mahmuda's wife and the children generous discount. Mahmuda had threatened to lodge a complaint against Muna. So you are to advise Muna. Okay. So what happened next is you must highlight this very important point. Maimuna is actually a sole proprietor of law firm. She's not a simple legal associate. She's not an employee. So one of the criteria to apply seizure annual by virtue of Section 32 LPA, as well as your Bar Council rulings, Chapter 8, you must give accountant's report, So this is also provided under your accountant's reports rules 1990. Okay, so case Yip Shoshan against Majlis Peguam Negara. Okay, and the second criteria is, of course, you must have a valid and also enforceable professional indemnity insurance of that particular year. And if you want to challenge Ken, you can go for judicial review, but unlikely she'll get the leave. So you come back to one more step. What is the issue with the law firm accounts? You must have two accounts. One is office account and another one is client's account. Office account means any fee that is chargeable to you, any disbursement, logistic fee incur, or your professional fee, you can put it here. The second part one is very important. Client's account. This account refer to the money payable to the client to settle their own liability. This is not your money. A lot of grave mistakes have been committed for utilizing the client's account money. Once you touch the client's account money, regardless what is the amount, what is your very pitiful reasoning behind that, you will get struck off. Okay, so client's account is very important. So you refer to your rule 3, rule 4 of your solicitor's account rule. Uh, and also rule 7 of your solicitor account rule. The famous case here would be Chong Yik Sun against, we have roughly discussed, and Nana Segaran. Okay, Nana Segaran. This is in your evidence law as well, computer generated document, section 90A. I hope you remember that. Okay, and interest. Okay, what about the dealing of interest? Because it's large amount of money, isn't it? So, based on your SADIR, this is Solicitor's Account Deposit Interest Rule 1990. Rule 2, if the amount more than 5,000 ringgit and you are not likely to move the fund within 4 months, by right you should deposit into the bank as an fixed deposit, FD. Okay, and then the interest by right should be given to the client unless there is a contrary written agreement between you and the party. Okay, so and another criteria to that exception will be if that money actually does not belong to the client. It's a trust, the money from a yaya's son, something like that. Then you do not need to pay interest to the client. Okay, so this is by virtue of BC ruling 2019, 14, chapter 14, the uh, point 10, 14.10. Okay, a solicitor may pay interest on the monies held as a holder, but they can charge some fees, reasonable fee for the process to put in money in fixed deposit, some administrative fee. Okay, and however, if you look at one case law here, GT Rajan against Lee Yok Lai, the case law actually mentioned that the interest, the lawyer can keep, Okay. So there is actually some contradictory position, okay, in terms of the laws and also the case law. Okay, so you can choose one and conclude. Okay, so since the case is drafted very against that Maimuna, in personal opinion, I will submit, I will go with the rules lah, say that uh, Maimuna must pay lah, okay? And the fund, the fund, the same fund itself cannot use to offset, cannot use to, oh, actually, I use that money to cover for other legal services because there is a distinction with clients' money and also the money that should be deposited inside the law firm's office accounts. So difference, you cannot use the money and mix the fund together. Okay, it's a big wrong. It's a big wrong. And discount, discount, I think solicitor remuneration order 2023, you can give up to 50% now. So if the house price itself, I think this house price itself, as stated, is already more than 1 million because 2.5 is the balance price, isn't it? So more than 1 million, you can give 50%. This is by virtue of your table B, first schedule, solicitor remuneration order 2023. You can only give discount on SPA, not other services. For example, legal services to the wife, the children. So generous discount, you have to submit that it may breach the rule. Okay, and complain. Subsequently, even this Mashmuda wanted to complain, isn't it? So I think you need to complete your answer with the ultimate issue of complaint. Can or cannot? Can, as a client, Mashmuda is as of right, can lodge a complaint to disciplinary board pursuant to your section 99 subrule 1 LPA. So based on the facts given, you are to advise Muna. So what eventually do you think will happen to Muna? I think she's doomed because she doesn't even have a client's account. This is a grave mistake. But I want to be extra cautious. I did not submit that she'll get struck off lah, because eventually this is the decision of DB. But I'm pretty sure that she will be liable for disciplinary punishment. Okay. Third question. Okay, hopefully you can end by 10. So Gaba, an advocate and solicitor, was retained by Kuat Gaga Perkasa. Okay. To defend a claim against the latter in a suit relating to an intellectual property infringement filed by a rival company, Strong Build Sanjiran Berhad. His good friend, Prakash Raj, who operates a business development consultancy, has strongly recommended Gaba to Kuat Gaga Berhad on promise that Gaba will split the fees with him. So usually you can see some similarity in the question. Usually touting share profit with lay person, something like that. So before his appointment, Gaba was asked to conduct a conflict check and provide a declaration on his expertise in handling this brief. Gaba was strapped financially at that time and decided not to disclose that his father-in-law holds 15% shares in Strong Build Sendirian Berhad, and that had also previously attended the shareholders meeting of the company as a proxy to his father-in-law, and his father-in-law contributes significantly to Gaba's financial need. Okay, you can see there's an issue of conflict of interest here. So he has also declared that he had been handed multitudes of litigations relating to intellectual property disputes where in truth he has never done so. So in fact, he had never studied the subject in university when reading law. So he had totally no idea what case is it all about. He has no expertise. When the matter came up trial, Gaba, still hungover from party the night before, asked his pupil to appear in court together with a letter seeking adjournment on the basis that Gaba is unwell. In the letter, Gaba undertakes to produce a certificate by a medical practitioner certifying that he is unfit to attend court. Adjournment was granted. Huh? Mm. So, as the matter was approaching for trial, Gaba wrote to solicitors for strong-billed Sendirian Berhad. Probably he never prepared, offering settlement of the claim and stated that if agreed, consent judgment can be recorded the next day. So during the day fixed for hearing, Gaba was late to court, and when asked for the reason for his tardiness and also on his undertaking, I mean, previous undertaking to submit MC, lah, where's your MC? He stated that I'm here, and when I say I'm sick, you should accept it. Anyway, you are paid to hear cases and I'll not be cowed by you. Now record the consent judgment as I know what is best for my client or I discharge myself. So he actually argue or exchange words with the judge. The judge stated that Gaba has committed contempt in the face of the court and adjourned the matter for 1 week so that Gaba could reflect on his actions. So what Gaga Berhad's directors were present and shocked to witness the incident as it never gave any instruction to Gaba to record any consent judgment. It wishes to discharge Gaba, advise Gaba. Okay. So, as I told you, my preference will be using this sort of heading. So you list down the issue first. Okay. So number one will be touting slash sharing profit with lay person. This Prakash Raj issue. So Prakash Raj, why you said is a amount to counting? Introduce client itself as a matter. Did not have any wrong, because lawyers need words of mouth to spread good names. For example, you spread good names about me, about my firm, Chris and Partner. So later on, we get recommendation. Provided you do not get any cut in the whole case itself. Not like in exchange of benefit. Not like this, or I put it this way. If you want me to teach you law, you have to recommend 10 clients to me. So that one is actually in gratuity already. You cannot do so. This will call as doubting. Okay, so Rule 51 LPPER strictly prohibited that. Okay, you cannot recommend clients for reward. Either it's monetary reward or some labor efforts, cannot do so. Okay, so Rule 52 LPPER stated that GABA should not share profit with Prakash Raj, who is not a qualified person. Please use your term exactly because eventually it is the wording of that rules that will go for question of law. So that is how important to use specific uh, wording, okay, keywords. And what about this fathers-in-law's substantial shares? So BC ruling 6.08 provided that if an advocate and solicitor is the director or substantial shareholder of one particular party, he should not. Okay, that means to say if I own which one? Genting Berhad, I'm the substantial shareholder, even though I'm not in reality. Okay, I cannot represent Genting in any suit. So this is what it meant. So but this is not possible because the father-in-law is actually the shareholder. But somehow or rather, there is some connection and somehow there is a conflict of interest. Because the facts suggested actually the father-in-law gave Gaba a lot of money also. So probably that money, part and partial of it, will come from the shareholding, okay, of the company. So you must evaluate it based on case to case basis. But eventually, to make your stand clear, I would say that Gaba should not take this case because it will probably embarrass him, affect his professional integrity. Rule 4, you rely on the case of Aris Mutia against Bumbena and Fiba, and Gaba is not likely to maintain independence since the father-in-law is the substantial shareholder. You use Rule 5 LPPER against, okay? And attendance of shareholder meeting. This is quite fatal lah. If you say father-in-law, I do not know, still okay lah. I mean, you wouldn't check your father-in-law shareholdings, isn't it? Whether the father-in-law will subscribe to any share. This is sometimes not a proper question to disclose to father-in-law. Okay, if you say you don't know, still okay. But the fact that you attend the shareholders as a proxy, will be fatal, So this is by Rule 28 LPPEA. So you elaborate more on this statement. So the fact that GABA might be called as a witness in court, we never know, If let's say the opposing counsel is extremely smart, they want to embarrass you or they want to nullify the whole process, what they will do is they'll subpoena you as a witness in the court even though it's not much of relevancy. You cannot even object, because this is the counsel right to subpoena witness, and it is for the court to decide whether the admissibility of this particular evidence is relevant or not. So section 136 of your Evidence Act, something like that, so difficult, huh? I will eventually said that GABA should not act as an advocate and solicitor in a related case. So there's an issue of misrepresentation here because he claimed that he's in fact very having some multitudes expertise in intellectual property, but in fact he did not have one. So use general rule 1631 fail to uphold dignity, memalukan profession name. Okay, and rule 4 professionalism of advocate and solicitor is highly impunged by his misconduct. Use this sort of uh, uh, the words lah, the legal words. Okay, and performance in court is also not good because he did not appear and also he did not actually get ready for trial. And one more important point, he lied to the court by doing some undertaking. In fact, he was drinking the day before, but he undertook. It means I promise you I will produce an MC. Actually, I'm sick, but this is a lie to the court. By right, as an officer of the court, you cannot lie at all because any lie will eventually be found out. Maybe not by court, but by the other opposing uh, party. Then you are doomed. So maintain some integrity, not just for the sake of for the case itself, but for yourself at large. Okay. And Rule 12 LPPER causing unnecessary delay to the proceedings because of adjournment. Okay. So GABA was actually falsifying undertaking regarding to his sickness. Okay. So this is all wrong. Elaborate more on that. So next issue, consent judgment. He abused the client's confidence. Rule 35 LPPER. You use the case of Nyosu O against G. Retina Sami. As you know, consent judgment is one of the very powerful settlement agreement among the party. One side it is not appealable, That means to say the matter finished that in that setting, unless you have some clerical mistake in the said consent judgment whatsoever. Otherwise, you can't even amend it. So when you abuse this sort of confidence and then you do not have any authority to enter consent judgment on behalf of the client, I think GABA will be eventually sued by the clients for negligence. Okay, and contempt in the face of court. Okay, disrespect court under Rule 15 LPPER. Actually, he was ending late again in the next date and exchange words with judge. This is strictly prohibited in the court setting. Whatever the judge said You cannot stand out and say that, oh, you are wrong in law, But however, you can put it in your submission lah, to say that the judge eventually khilaf, made a mistake in the interpretation. But you
So apa
cannot just
like
stand
apa
up
lah?
and then point your finger against the judge and say that, oh, it doesn't work
Tak
this
rasa
way. This
penguasa.
is not the process that you challenge the judge and also the court. Reason being, the court does not just represent themselves, but the Yang di Pertuan Agong is behind. So you cannot do like that. So GABA is likely to be liable. And lastly, you must also address the issue of discharge here. So what Gaga may apply to discharge GABA by notice of application. Why I say so? Because you need to
Kali
advise
ya, orang
GABA
makan
as a
burger.
whole, isn't it? So there's an issue of discharge, you have to advise. But what
Ah,
Gaga, the Sendirian Berhad, the poor company lah, that Sui lah, engage GABA,
kena saya
still need to
bawa
pay
tu
the
Sawama
fee.
punya road.
Otherwise, a new
Sawama road.
advocate solicitor cannot be appointed to represent Gaga. Rule
Apa double dia
54
kena.
LPPER. So
Apa
this
macam
one is also one challenging area, especially when you are in time to come. I'm
you
sure
pakai
you
tu
will
Sawama road tu
become a lawyer, and then you have to represent a leftover case,
berasa.
a pending case. So that you must make sure your client, your new client, settle the previous fees. If not, you might be caught for ethics rules, if people will report you or undercut them. Okay. And finally, last question. With reference to provisions of Legal Profession Act 1946 and 8 of decided case, and explain the meaning of misconduct and 4 instances of misconduct that have attracted the sanction of striking off from the roles. So must be a grave impropriety. Okay. So for A, you use the meaning under your section 94 subrule 3 of LPA to say that misconduct could be a positive act, that means the conduct itself, or a negative act, an omission to act in Malaysia or elsewhere as professional capacity or otherwise, which amount to grave impropriety. A very serious form of
Sawama road.
behavior that lead to wrong judgment. I mean the judgment of wrongful impression on you. Okay, so the examples of misconduct are actually well covered in your subsections A to O. There are actually 4 instances that will attract striking or struck off the roll. Okay, number one, the most important thing, and I could not help myself to repeat, that is to use the client's money to settle own liability. Very, very, very important. Not a cent should be moved out from client's money. So that's why you cannot pass your account to some other person. Usually lawyers, regardless, I mean how hi-fi they go, usually they manage their own account. This is the reason. Otherwise, 1 cent go missing, you'll get caught and then you'll get struck off. Very serious punishment. So this is by virtue of your section 94, subrule 3O, Chong Yik case. Famous case. Second thing, criminal conviction, especially those with regards to fraud. Sometimes drunk driving also can. Drunk driving, like you take some recreational drug, you go disco and then you drink somebody's drink, you are not, you're innocent, somebody set you up or somebody just want you to feel high. They put some thirsty pill inside your drink. You might be struck off also. So be careful with that. So any criminal conviction that you bring some disgrace to the legal profession can lead to striking off. Okay, like case of VK Lingam. VK Lingam eventually got struck off. Okay, so dishonest or fraudulent activities, criminal breach trust, of course lah. This one, okay, you are deemed to be a person with no good character. So W.E. Balasingham against Bar Council. And should you be disbarred from any countries, you will get struck off also. This is also something last time I used to see people with multiple licenses. That means they can practice in Malaysia, they can practice in Australia, Brunei. Should any of the council, I mean the law society or the legal counsel of that particular country bar you from practicing, probably the bar council get to know you'll get struck off also in Malaysia. Okay, you can use the case of Tan Chow Wang. Okay, and 4B is what? 4B. Okay, Don and Co is a law firm with 30 partners and 15 associates, so very big firm. The firm was set up more than 10 years ago and had a steady stream of foreign and overseas clients. Don and Co had been in a strategic alliance with Qantas, a law firm established in Republic of Germany. Both firms wish to enter an international partnership, discuss whether such partnership is possible and permissible, and relevant statutory provisions. So again, you have to use the long naming. This legal profession licensing of international partnerships and for qualified foreign law firms and registration of foreign lawyers rules 2014. Okay, so and under section 40 FLPA, you can actually set up a international IP. Okay, international partnership. We call IP lah. So a foreign law firm and a Malaysia law firm can actually make together. So contrast Don and Co. joint application can submit a form to Bar Council in this form A lah. And you must put a name lah, either, but it must be a combination of the name between the firm. You cannot just suddenly out of nowhere you go and name this firm as Chris and Partner, a brand new one. Cannot. It must come from the wording Don and Co and Frontos. So probably the good name here will be Dontos. I don't know. Dontos probably is a good name. So the foreign law firm and Malaysian law firm should have both be of good reputation, and none of the lawyers is subjected to disciplinary proceedings, because eventually the legal society is very alert to fraudulent activity towards money laundering or any sort of terrorism activity or any sort of unlawful activities. They don't allow one. Okay, uh, because sometimes the law firm being utilized as a vehicle, you know what I mean, to this sort of unlawful activities, because we are subjected to legal privilege. Mm. And only permitted areas as I have discussed, and the foreign lawyers cannot appear lah. This is same. And okay, the transaction of that particular firm, you must show that you are specialized. The Qantas must have shown they are specialized in that area law. For example, Germany intellectual property. But how to show to the court that actually you do? I mean, the Qantas does possess the expertise is by they have to see your account. They don't see whether you got an LLM or PhD in intellectual property law of German. Not like that. They have to see your transaction, financial account. How many cases that you have handled? What is the value of the case? Does it reach 5 million, 10 million USD, for example? So this is the thing how the selection committee take into account. And the track record of the firm you have to look, and then uh, to ensure at least one foreign, because it's a joint thing, right? It's at least there must be a one foreign lawyer in that particular international partnership, and also an equity that particular person must be also an equity partner. That means to say must be a shareholder lah, of the frontos. Okay. So and must reside in Malaysia not less than 182 days in any calendar date. Okay. So these are very strict rules subjected to formation of whether it's foreign law firms, foreign lawyers, as well as international partnership. Because we are so scared that once we approve the foreign lawyers to do something, subsequently they sapu the money and then run back to German for no reason. The clients in Malaysia suffer loss and then probably need to go to Munich to pursue the case. So difficult, you know. Okay. So Malaysia law firm should not have less than 60% of that total shareholding. Okay. And 3-year business plan. So these are all quite strict rules. And you have a lot to argue. If you are not very familiarized with this, I don't think you should do. You see, CV of the Malaysian lawyers should contain the whatever information, and also important part is the indemnity insurance. Okay, mandatory limits is 5 million. Usual law firm a few 100,000 ringgit. Okay, but this one must reach 5 million, cover worldwide jurisdiction. Okay, and any change with the professional indemnity insurance must inform to bar counsel. Okay, very important. And this is this is it. Still very long. Okay, this one never mind. I think foreign law one. I will I will send this slide to the group. Then subsequently you can read in your own reading. Rule 6, the 25%. The 25% is the old ruling. Maximum last time can give up to 25%. Now, if more than 1 million, if you look at the first schedule, table B, Susunan B, okay, I send over to you the 2023 SRO. You can see that how the discount had been increased to 50%. Okay, nowadays 50%. So far, is there any question? We are reaching 10 o'clock. Ngam ngam. Any question?